All right, Mr. Pope, we'll commence this meeting of the Tennessee Board of Equalization on August 11 in the Court of the Hall building. Welcome to everyone who's here today. Mr. Pope, would you call the roll of the members?
Yes. Commissioner Giorgano? Ms. Erin Merrick?
Here.
Ms. Burchett? Treasurer Lillard?
Here.
Mr. Fleming, can you hear us and give us a shout virtually?
Yes, here. Can you hear me?
Thank you.
All right, a quorum being present then, we'll go to the next item, which is item number 2, public comment period. Mr. Pope, you want to present this item?
We had no requests for public comment. However, we did receive several requests to present oral argument related to agenda item number 8. The board may hear that now or decide to hear it later. It is also optional if the board does not want to receive oral argument today.
Okay, we'll take that up when we get to item number 8 here, okay? All right. Okay, no public comment then. Item number 3, review of the minutes of April 14, 2025. The draft is in our packet and all. I've reviewed them and we'll entertain a motion with respect to the minutes. All right, motion to approve.
Second.
Does that have a second? All right, any discussion? Seeing none, since we have an in-person quorum, I believe we can do this by voice vote. So all those in favor of the motion to approve the minutes signify by saying aye.
I apologize. We do have one member on virtually. I believe when we have one member virtually, it is
Okay,
required
so
to do a roll
have
call.
to call the roll each time, okay?
I believe so.
All right, call the roll, Mr. Pope, on the motion to approve the minutes.
All right, we'll start with Mr. Fleming. Mr. Fleming, your vote on the motion to approve the meeting minutes from April 14th? I got a thumbs up. Okay, I think we might be having some technical difficulties.
Really need a little voice action for the purpose of the tape, but at any rate. All right, we've got other members that are present. Let's proceed with the roll call.
All right. Commissioner Giorgano? Aye. Ms. Erin Merrick?
Aye.
Ms. Burchett? Treasurer Lillard?
Aye. All right, so the minutes are approved. Next item is item number 4, the assessment education program.
We have Mr. Brian Kinsey, the Director of the Division of Property Assessments, here to present.
All right.
Good afternoon, members of the board. Number 4, assessment education program, couple of parts of this. The first part is we'll be asking you to approve 2 certifications, 2 types of certifications, Tennessee Certified Assessor and Tennessee Master Assessor. For the group under Tennessee Master Assessor, we have Assessor of Property of Loudoun County, Michael Campbell, Williamson County employee Macy Truitt, and Division of Property Assessments employee Matt Carpenter. I would like to point out that the Loudoun County Assessor, Michael Campbell, is in the room. So appreciate Mike being here to see this honor bestowed upon him. Also, for the other level of certification is the Tennessee Certified Assessor certification. We have 3 Division of Property Assessments employees that we're asking you to approve for that today: Tyler Braden, Andrew Hickman, and Alicia Stevens. All of these folks have undergone extensive classroom training, passed various exams and/or case studies, and have a certain number of years of experience that qualify them for these certifications.
Okay, do we have a motion for approval of the items under 4A, the approval of the assessment designations and the Master Assessor and the Certified Assessor program? Is there a motion?
Motion to approve.
All right, motion to approve. Second by Commissioner Giorgano. All right, any discussion? Seeing none, Mr. Pope, would you call the roll on the motion to approve?
I'm going to again start with Mr. Fleming on our virtual.
Yes.
You can hear you for that one.
Yes.
And then Ms. Burchett?
Yes.
Commissioner Giorgano? Aye. Ms. Merrick?
Aye.
Treasurer Lillard?
Aye. All right, that item's approved, and we'll go to 4B now, which is the resolution approving payment of additional compensation to assessors and deputy assessors for professional designation, as shown in the materials. Mr. Kinsey.
4A was a nice segue into 4B. Tennessee law and rules promulgated by this board set forth incentive compensation for assessors and deputies assessors that attain these certifications, such as the ones you've just approved, the TCA and TMA. And as such, the Division of Property Assessments works with each county annually to determine which employees, either the assessor or deputy assessors, qualify for these incentive payments. And they're set at various amounts depending on which certification they have, a TCA, TMA, or CAE. So we've provided you documentation that shows by county and then by employee within that county the incentive payment that each of these folks are entitled to, whether it be a full year or a prorated amount of year, depending upon when they earned it or when they left or entered employment. If I can answer any questions if you have on that. Otherwise, that's pretty much all I have to say about it.
Any questions, Mr. Kinsey, in regard to that? Seeing none, the chair will move approval of item 4B. Is there a second? A second by Commissioner Giorgano. Any discussion? Seeing none, call the roll on the motion to approve 4B.
All right, I'm going to start with Mr. Fleming.
Aye.
Ms. Burchett. Commissioner Giorgano. Ms. Merrick.
Aye.
Treasurer Lillard.
Aye. All right, the ayes have it, and that item is adopted. Our next item is item 5, review of reappraisal plans and programs. Mr. Kinsey, you're recognized.
Yes, sir. So what we have before you today we have 3 counties that have reappraisal plans that we would be asking you to consider not changing, but approving. Sorry. 2 of these are for 2025 reappraisal counties, that being Bradley and Williamson. Typically, these plans would be ready in your April meeting, but these counties were running a little bit late, but we have worked with them, received their plans. So Bradley and Williamson are 2025 counties that are submitting their standard plans. Bradley staying on a 4-year cycle. Williamson is actually reducing or requesting to reduce from a 4-year to a 3-year cycle. You'll also see Hardin County on here, which actually reappraised in 23 on a 5-year cycle, but has come before this body requesting that cycle be reduced to a 4-year cycle. So before you today, a 4-year plan and cycle from Bradley, a 4-year plan and cycle from Hardin, a 3-year plan and cycle from Williamson. And just as a matter of note, Shelby County was also a reappraisal county this year and still is working on their reappraisal plan. The Division of Property Assessments has been working with the county on this. A property assessment consultant from CTAS is working on the plan with the county. Where the holdup is at the local level, just getting it through their local county commission. We have every reason to expect that will be completed. They're continuing their work as they normally would in lieu of this formal plan. We would expect to be able to bring that plan to you in your next meeting in October.
Okay. All right, any further questions? Seeing none, do we have a motion with respect to this item? All right, the motion to approve is our second.
Second.
All right, second by Ms. Merrick. All right, seeing no further discussion, Mr. Pope, call the roll on the motion to approve.
Mr. Fleming, we'll start with you virtually.
Aye.
Ms. Burchett. Commissioner Giorgano. Ms. Merrick.
Aye.
Treasurer Lillard.
Aye. All right, so that item is approved, item number 5, and we'll move to item number 6, report of Director of the Division of Property Assessments. Materials are on pages 15 to 26 of your materials. Director Kinsey, you're recognized.
Thank you. So this is the division's annual report that we are required to present to this body. It's in the law, Tennessee Code 671202. And it, you see it every year. It summarizes the activities that we've done throughout the year, whether it be training that we provide for assessment professionals, support of various computer systems, CAMA systems, geographic information systems, the work we do with tax billing, administering the property tax relief program. Both very important. Just want to point out that the work that we do enables local jurisdictions to bill $2.8 billion in local property taxes. And the property tax relief program we're administering, we paid out over $43 million this past year administering the tax relief program. So the report touches on all of these things and various other forms of assistance and oversight that the division provides. And present this report to you today for your acceptance, consideration, or I'm not sure whether you actually have to formally approve it, but that is not my call to make.
This is an informational item.
Be happy to answer any questions if you had any.
Okay, any questions of Mr. Kinsey about the report? If not, without objection, the board will acknowledge the receipt of the report. So, all right, thank you for that. Item number 7 is the next item, scheduling of public utility assessments review and certification. Mr. Pope, you want to present this item?
Yes, this is an informational item only. This is it's basically just the announcement that the board will reconvene on Monday, October 20th. Excuse me, I think the note says 9 a.m. I believe it's at 1 p.m. I got to double check on that. But we will meet on October 20th in the same room and also virtually to announce those public utility assessment and certify those assessments made by the Office of State Assessed Properties. They'll go through an informal review period essentially right now, and then the board will certify those finally in October.
Okay, any questions of Mr. Pope in regard to that? All right, then without objection, the hearing as set forth will be scheduled on Monday, October 20, 2025, at a time to be announced by the staff when that's clarified. All right, next item then is item number 8, review of petitions for review on pages 27 through 29 of your materials. Mr. Pope, you want to present this item, please?
You have currently, I believe, 5 petitions for review at today's meeting. The board has several options with these, as well as you've received 3 requests to present oral argument on 3 of those petitions. Oral argument is discretionary within the board's determination, so you may receive or may not receive oral argument. It's up to you. You may also establish how long you want to receive that for. The board has several options with regards to action on each petition before the board today. You may decline to exercise review entirely, which would mean that the decision of the administrative judge would become the final action, and the parties may then appeal to Chancery Court. The board may also decide to elect to review the case, may delegate review to one or more persons, one or more board members. The board may also defer action to another meeting if you want to have a full otherwise hearing on it. The board may expand the administrative record and hear additional evidence if you would like to. Otherwise, it's generally restricted to the administrative record.
Okay.
I've prepared a short case summary for each appeal if you'd like to go through them one in order.
Yeah, let's take these in order, if you would, if you'd take up the first one.
Our first appeal today is for Roland and Nicole Baggett versus the Davidson County Assessor's Office. We have Mr. Roland Baggett representing himself, and then the Assessor's Office represented by counsel. The property owners, Mr. and Mrs. Baggett, as owners of the subject property, filed an appeal with the state board following an appeal to the Davidson County Metropolitan Board of Equalization for tax year 2021. Administrative Judge Richard Murrell heard the matter on June 18th, and thereafter had post-hearing briefs and a transcripts of the recording were filed in September, and an initial decision order was issued in January. Ultimately, the administrative judge found the taxpayers failed to meet the burden to establish a more credible value than that of the Davidson County Metropolitan Board of Equalization. The administrative judge elaborated, quote, "Their burden is not to demonstrate that the assessor's original assessment of the subject property was flawed, but to affirmatively establish a more credible valuation," end quote. The administrative judge found the taxpayers' comparable sales were not adjusted for differences between the utilized sales and the subject property. Therefore, they were an unreliable indicator of value and were insufficient to support a more credible valuation.
Okay, we had a request to speak with respect to this matter in the past. The board has allowed 3 minutes per each side to present brief argument if they wish to do that before the board. Is that the mechanism board wishes to pursue today? Okay. All right, then let's call up the first person to speak on this, which would be the appellant, Roland Baggett, property owner. Come on up.
I spoke to Mr. Baggett previously, but I will keep a timekeeper and I will hold up a sign showing when we have 1 minute remaining and when your time has elapsed.
Okay, Mr. Baggett,
You'll make sure to press the green button if you're sitting at the podium.
you can stand at the podium or sit, whichever one you want to do.
Yep. Let me just make sure we can.
If necessary, we just
Yeah,
sit there, if you would,
maybe
you know.
be safe and let's move to the table. Thank you.
That's not a problem. Can you hear me?
Yes,
Great.
just give your name, please, if you would.
Ladies and gentlemen of the board, thank you for hearing me today. My name is Roland Baggett, and my wife, Nicole, and I are the appellants herein. Mr. Pope has given you a good brief summary of the underlying proceedings in front of Judge Murrell. There are things that need to be reviewed, though, including evidentiary decisions that were made to allow, for example, the assessor's employee who has expert knowledge but was not disclosed as an expert on the testimony and should not have been allowed to provide testimony, as well as things like judicial estoppel, where the assessor, in response to verified interrogatories, stated that they did not have a contended value. They didn't contend something different from what the taxpayers, my wife and I, had contended. And so the process has been, unfortunately, a long slog, and we're here finally today. Of note, on the post-hearing briefs, and this is part of the record that you have, one of the things that we pointed out was that there is at no point in time during the process that the assessor was able to provide any evidence that supported the original assessment or what their contentions were later on. It was always some ad hoc grabbing from one place or the next. And that is in reality because of the computer-assisted mass appraisal software that they use. They have delegated the entirety of their duties to software. And they are not actually going out and reviewing each property or even a photo of each property every 4 years as required by statute. The current property picture of my house was taken in 2015 before a use and occupancy permit was issued. There isn't anything that is showing that they are actually doing their duties. And so one of the questions that I have raised, and I raised this with Judge Murrell, was whether or not the assessor of property has sufficient legislative authorization to actually do this delegation. And my contention is that there is not sufficient legislative authorization. And the United States Supreme Court and the Lieber Bright versus Ramadio case, and then West Virginia versus EPA cases have clarified that there must be clear legislative authorization for the exercise of the powers. And if it is a regulatory power that's being exercised, the regulatory power has to have clear legislative authorization, and it simply is not there. The assessor is going to contend here that they're following the process that is provided by the comptroller's office, and the comptroller's office has promoted or promulgated manuals for sales data collection and verification. My time is up. If I could
Well,
finish.
let's just wrap it up. Go ahead and wrap it up, Mr. Baggett.
Okay. That manual that goes with it is 12 pages long. And of note, it says that all transfers may be accounted for by utilization of a maintenance log, and then it goes on to talk about the impact system that is there. It doesn't say that they get to delegate their duties to the software.
Okay. Thank you for your comments. All right, next is Brooke Thompson, attorney for the Davidson County Assessor's Office. Okay, you're a deputy, okay?
So I think we have an update. I believe you can introduce yourself as well.
Good afternoon, members of the board. My name is Sam Keene. I'm an assistant metropolitan attorney representing the
Okay,
Metropolitan
very
Justice
good.
today in this matter. Just to respond to Mr. Baggett, I think first he said that the assessor's office did not put forth a contingent value. Of course, this board knows that the assessor's office is not required to put forth a contingent value. The burden is on the taxpayer to show that the value established by the Metropolitan Board of Equalization is incorrect and should be changed. Mr. Baggett spoke at length about his issues with the Metropolitan Assessor's Office use of our CAMA system, but again, he failed to put forth any sort of evidence or describe any evidence that he put forth in front of the ALJ that would give the ALJ any reason to change the assessment determined by the Metropolitan Board of Equalization. And this is because he has no evidence that would support a change to the assessment. In front of the ALJ, he did use what he said were 27 comparable properties to try to establish a new assessment. But the ALJ correctly pointed out that these comparables were not used within the parameters of any established or accepted market value of theory, market theory of value that could be used to possibly assess a property. The ALJ did, however, find compelling the 4 comparables that were used by the assessor's office. Not that that matters, because first and foremost, the taxpayer has to establish that the assessment of the Metropolitan Board of Equalization was incorrect, and he has not done so here. Obviously, Mr. Baggett takes issue with the Metropolitan Assessor's use of a CAMA system. I would disagree strongly that the Metropolitan Assessor's use of a CAMA system is not enabled by legislation, and our use of our CAMA system is obviously overseen and guided by both this board and the Division of Property Assessments. And we believe that we fully comply and are subject to routine audits by both the Division of Property Assessments and this board. And we follow the manual, and the manual instructs us to use a computer-assisted mass appraisal system. Additionally, I think Mr. Baggett is incorrect about whether or not we view each property. We certainly do. We employ hundreds of thousands of man-hours each year to make sure that we're complying with all our statutory duties in reviewing each property, whether that be a physical inspection or through pictometry. So I think that Mr. Baggett is just incorrect. But again, it's his issue with our CAMA system isn't the point here. The point is that he just hasn't established a more credible value than what was established by the Metropolitan Board of Equalization. And so the ALJ ruling should be upheld.
All right, thank you very much. All right, members of the board, any discussion on this case based on that discussion? Yeah, Mr. Commissioner Geragano, you're recognized.
Mr. Chairman, I would just on reviewing what's been presented to us, seems like the ALJ is fully considered.
Okay. Okay, then I assume you're making a motion to confirm the judgment of the ALJ and adopt it as the board's finding. All right, okay, I'll second that motion. Is there any further discussion? Mr. Pope, do you have anything further?
No, I wasn't sure if there were any other questions on procedure from the board.
Okay, we don't see any other questions from board members, and call the roll on the motion to adopt.
All right, we'll start with Mr. Fleming virtually.
Aye.
Ms. Burchett? Commissioner Geragano? Ms. Merrick?
Aye.
Treasurer Lillard?
Aye. All right, that's unanimously aye, so that matter is adopted and the findings of the ALJ are confirmed and adopted by the board. Next item is item number 2, Bethany Realty LLC versus Davidson County Assessor's Office. And Mr. Pope, you want to present this case briefly?
Yes. Bethany Realty LLC appealed to the state board from the Davidson County Metropolitan Board of Equalization for tax year 2021, then later amended their appeal to include tax years 22, 2023, 2024. Administrative Judge Claudia Padfield heard the matter on October 17th, 2024, and issued an initial decision and order on March 18th with a corrected initial decision and order issued April 22nd, 2025. The administrative judge found that Bethany Realty LLC failed to prove by preponderance of the evidence that a reduction in value from the local board was warranted, and that the Davidson County Assessor's Office proved by preponderance of the evidence that the local valuation should be increased. I do believe we have a request from Mr. Wesley Vaughn, a registered agent with the board and representative for the appellant who's appearing virtually, I think has requested to speak.
All right. Request from Wesley Vaughn to speak. Mr. Vaughn, you present?
Yes, I'm present.
Okay, virtually. All right, very good, sir. Going ahead. You got 3 minutes.
Yes, thank you. The subject property, as Mr. Pope described, is a skilled nursing facility in Nashville built in 1983. The original proposed value for 2021 was just over 11 million. Both the taxpayer and the county assessor presented valuations based primarily on the income approach. The taxpayer's analysis indicated a value of $8,514,000. The supporting evidence that the taxpayers' representatives included were 3 years of operating statements, 3 years of actual occupancy reports, skilled nursing cap rates from CBRE and Jones Lang LaSalle, national occupancy data from the National Investment Center for Seniors Housing and Care, as well as national expense data from Clifton Larson Allen. In contrast, the assessor's analysis indicated a value of just over 14 million for 2021, with that value increasing for subsequent years. The assessors provided supporting documentation was asking rents, not actual rents, of skilled nursing facilities, hospitals, and even medical offices from across the country. No documented adjustments to these rents were provided. A 3% vacancy rate that the county assessor admitted to coming up with on his own, as well as an 8% cap rate from undocumented interviews with unnamed brokers and an assortment of CoStar screenshots. Despite this lack of tangible evidence, the ALJ sided entirely with the assessor and raised the property's value. The taxpayer understands that it must overcome the burden of proof in these proceedings, but it is neither fair nor consistent to determine that the same burden was met by the assessor with hearsay, made-up figures, and not a single market rent or market sale comparable within the state of Tennessee. The judge's own words when referring to taxpayers, as recorded on page 11 of the transcript, raises questions about the judge's biases and intentions. The judge said, quote, "They don't understand that I can even increase the value. So they come thinking it's either going to be the same or it's going to be lower. But the truth is they can not only lose, but lose pretty big." This statement, combined with the decision to disregard well-sourced and relevant evidence, demonstrates a failure to apply proper valuation standards. In light of these facts, the petitioner requests that the state board reverse the initial decision in order or modify it to follow credible market evidence in its valuation of the subject property.
All right.
And that's all I have. Thank you.
Okay, thank you for those comments. All right. Let's see, we have Mr. Brooke Thompson or his office representing the assessor.
Thank you, and members of the board. Contrary to what Mr. Vaughn says, we believe the assessor did provide proper market data to value this property. The ALJ considered all the evidence that was submitted, including evidence of a deed of trust that was taken for over $16 million, which is still more than what we asked be put on the property. So we think that the evidence that the ALJ considered was supported, and she made the correct decision.
Okay.
I'll answer any questions, Your Honor.
All right. Okay, there are no questions, and thank you, Mr. Thompson, for your statements there. All right. Members of the board, let's go into discussion on this matter. Thank you, Mr. Thompson, for that. And do we have any comments on this case, Bethany Realty versus Davidson County Assessor's Office? I mean, from reviewing the record on this matter, I'm inclined personally to move to affirm the findings of the ALJ and adopt it as the board's decision on the matter, unless there's any further thought about that from other members of the board. Okay, seeing none, that's my motion.
I'll second.
All right. There's a second on that. Seeing no discussion, Mr. Pope, call the roll on the motion.
Mr. Fleming,
Aye.
Ms. Burchett, Commissioner Giorgano,
Aye.
Ms. Merrick,
Aye.
Treasurer Lillard.
Aye. All right, did we get Mr. Fleming too? Did we get him?
We can start with Mr. Fleming.
Voted, okay, all right. All right, that's unanimous in favor of that decision on that matter. On item number 3 is the next item, which is Mary Queen of Angels, Inc. versus Davidson County Assessor's Office. Mr. Pope, introduce this item.
Thank you. Mary Queen of Angels appealed again to the State Board of Equalization from the Davidson County Metropolitan Board of Equalization for tax year 2021 and amended its appeal to include tax years 2022, 2023, and 2024. Administrative Judge Claudia Padfield heard the matter on November 17th, 2024, and issued an initial decision order on March 25th, 2025, with a corrected initial decision order on April 21, 2025. The administrative judge found Mary Queen of Angels failed to prove by preponderance of the evidence that a reduction in value from the local board was warranted, and that the Davidson County Assessor's Office did prove by a preponderance of the evidence that the local board valuation should be increased. We again have Mr. Wesley Vaughn on behalf of the taxpayer and Mr. Thompson on behalf of Davidson County Assessor's Office.
All right, Mr. Vaughn, you're recognized.
Yes, thank you. Yes, this is another skilled nursing facility. It was built in Nashville in 1987. The original proposed value for 2021 was $6.7 million, thereabouts. Both the taxpayer and the assessor submitted valuations based on the income and cost approaches. Ultimately, the ALJ ruled in favor of the county assessor's cost approach, but modified the assessor's depreciation factor up to 45%. This ruling still raised the property's tax value. The ALJ's order has 2 flaws that warrant correction and review. First, there is a major mathematical error. The ALJ adopted a 45% depreciation rate, but incorrectly calculated it by just adding 20% depreciation to the assessor's 25% depreciated value. This approach or this calculation effectively applies a 40% total depreciation, not the 45% determined in the ALJ's ruling. The correct math would have been to apply the 45% depreciation to the assessor's replacement cost new. This is an indisputable error that must be corrected. The specific figures are detailed in the taxpayer's petition to the SBOE. The second error that the ALJ made is the inclusion of soft costs and entrepreneurial profit. The assessor's cost approach, which the ALJ accepted, includes both of those items. Yet the assessor provided no supporting documentation or third-party sources to justify these assumptions. The assessor simply stated in the record that these factors are, quote, common knowledge. In contrast, the taxpayer provided presentations from Marshall and Swift and excerpts from the Appraisal Institute detailing why these costs cannot be included in the cost approach for the subject property. The ALJ's initial decision itself states that to meet the burden of proof, the party seeking to change the assessed value must show that a preponderance of the evidence supports that change. It is unreasonable to conclude that the county met this burden without offering any actual evidence. In light of these facts, the taxpayer requests that the state board modify the initial decision. It is evident that the ALJ misapplied the findings of the initial decision in order, and it is also clear that the ruling was based on unsubstantiated assumptions that do not meet the burden of proof. Thank you.
Thank you, Mr. Vaughn. Mr. Brooke Thompson for the Davidson County Assessor's Office.
Just briefly, Treasurer Lillard. Contrary to what Mr. Vaughn said, we believe the Davidson County Assessor's Office did submit a cost approach that was in line with accepted appraisal practices. That does include soft costs and entrepreneurial profit. The administrative judge considered that and agreed with that. With respect to the additional obsolescence that the administrative judge found, she decided how much more obsolescence should be added, and she added that. And for the taxpayer to come back and say she added the wrong amount of obsolescence when she was making the determination of how much to add, it just doesn't stand. And so we believe the ALJ's order is supported by the evidence. We believe she made the right decision, and we think it should be affirmed.
Okay. Any discussion from members of the board on the matter? Commissioner Jerry Gano.
Was actually hoping to ask a question, Mr.
Okay,
Thompson,
sure.
if we could.
Mr. Thompson?
Thank you, Mr. Thompson. I believe the appellant asserted a mathematical error in his first point. Could you enlighten us on that?
The assessor submitted a cost approach that had some obsolescence factored in. The administrative judge determined that more obsolescence should be factored in. We don't particularly disagree with that, if that's what she thinks the evidence suggests. So she added in some extra obsolescence. They are alleging that she added it incorrectly, but I don't know how they know exactly how much should have been added when she was the one making the determination as to how much to add. And so I agree that the ALJ added extra obsolescence. We don't disagree that that was inappropriate, but we think what she did was appropriate.
Thank you.
Okay, any further questions, Mr. Thompson or anyone else on this matter? All right, thank you very much. All right, any discussion on this case? Again, based on the record in this matter and listening to the arguments that have been made here today and considering these issues and the extensive record in this, I move to adopt the findings of the ALJ and confirm them and make it the decision of this board.
I'll second.
All right, I have a second on that by Commissioner Jerry Gano, and that's in regard to the case of Mary Queen of Angels, Inc. versus Davidson County Assessor's Office. Mr. Pope, call the roll on the motion.
Mr. Fleming?
Aye.
Ms. Burchett? Commissioner Giorgano?
Aye.
Ms. Merrick?
Aye.
Treasurer Lillard?
Aye. All right, so that's unanimous in favor of the motion. It's adopted. The next two items, item number 4, Kasai North America, Inc. versus Coffee County Assessor's Office, and also item number 5, Michael Huddleston versus Dixon County Assessor's Office. Is there anyone here to be heard on no one filed a request to speak on this, but.
I did not receive any request to speak on either item.
Okay. All right, would you just briefly summarize, Mr. Pope, for the record, both of these cases, and if without objection to the board, we'll consider them together in terms of listening to your explanation, okay?
Okay. Item appeal number 4 for today, Kasai North America versus Coffee County Assessor's Office. Kasai North America Incorporated appealed to the State Board of Equalization through the registered agent Brendan Baker from the Coffee County Board of Equalization for tax year 2023. Administrative Judge Richard Morrell heard the matter on October 15, 2024, and issued an initial decision and order on March 20th, 2025. The administrative judge found the appellant, Kasai North America, ultimately failed to support a non-standard valuation for the tangible personal property assessment under appeal. The administrative judge upheld the value determination by the Coffee County Board of Equalization as the tax year 2023. Appeal number 5, and our last appeal petition for appeal of initial decision order for today, Michael Huddleston versus the Dixon County Assessor's Office. In this appeal, Michael Huddleston appealed to the State Board of Equalization from the Dixon County Board of Equalization for tax year 2024. Administrative Judge Richard Morrell heard the matter in April 2025 and issued an initial decision order on April 23rd, 2025. The administrative judge found Mr. Huddleston failed to prove by a preponderance of the evidence that the Dixon County assessor acted incorrectly or unlawfully as she determined that 7.8 acres of an 87.8 acre tract had not been included in Mr. Huddleston's 1993 Greenbelt application. The administrative judge upheld the assessment of the 7.8 acres as farm property, but clarified the taxpayer may submit a new application for the Greenbelt assessment program for the entire tract of property.
Okay. Any questions about either one of those cases? All right. Again, without objection to the board, I'd like to take these together. Item number 4 and item number 5. I've read the record on both of these, and I'm sure y'all have too. Looked at that, and based on that, then I would like to move to adopt the findings of the ALJ in both cases and adopt them as the findings of our board. Is there a second? I have a second from Ms. Burchett. All right. Seeing no further discussion, Mr. Pope, would you call the roll on the motion on both of those matters, items 4 and 5?
Mr. Fleming?
Aye.
Ms. Burchett? Commissioner Giorgano,
Aye.
Ms. Merrick,
Aye.
Treasurer Lillard.
Aye. All right, so that's unanimous, and the motion in both cases is adopted. All right, and that brings us to the next item on our agenda, which is item number 9, elect a vice chair pursuant to Tennessee Code annotated 4-3-5102. The floor is open for nominations for vice chair. I will say at the outset of this that it's a great honor and distinct pleasure to serve as your vice chair over the last 2 terms, but if anyone else wants to do this, I'm just more than gratified to give it to you. So,
Mr. Chairman, I would like to nominate yourself, Treasurer Lillard, to continue as our chairman.
all right. I just want to know if the pay is going to be increased or anything like that, so. All right, we have a motion. Is there a second for the
Second.
motion? A second, all right. Then, Mr. Pope, call the roll on the motion.
Mr. Fleming,
Aye.
Ms. Burchett, Commissioner Giorgano,
Aye.
Ms. Merrick,
Aye.
Treasurer Lillard.
A reluctant aye. Okay. All right, it's unanimous. I'm reelected. All right, anything else to come before the Tennessee Board of Equalization today, Mr. Pope? Anything else?
Final action is adjournment.
All right, we thank you for all the good work that you and the staff of the Comptroller's Office do, and we thank the litigants who appeared before us today and everyone else in regards to this matter for the state of Tennessee. Have a great day, and we're adjourned.